public order is the most fertile ground for the government justifying curbs on free speech. If you remember, it was added by the First Amendment. And public order has been differentiated from law and order and security of state. Justice Hidayatullah very picturesquely in Ram Manohar Lohiya's case in 1966 said, imagine three concentric circles. One, law and order, two, public order, and three, finally, security of state. Each one getting smaller and smaller. And it is only when it is security of state and law and order that you may curb free speech, not when it's a mere law and order problem. So, he made this distinction between two drunks having a quarrel, for example, and being violent with one another. Pure law and order problem. You cannot interfere with what they say. On the other hand, you have a public order problem of two, let's say, religious groups fighting each other and a riot being caused. Then only may you interfere and not otherwise. And this brings me to a very interesting and important test laid down by the US Supreme Court, again followed by us, which is that unless there is a clear and present danger, they put it beautifully, of some violence or some untoward act taking place as a result of the speech, you cannot curb free speech. And this was very felicitously put by Justice Holmes, who was the author of several judgments in the World War I period in the United States. And in Abrams, he was a dissenter. And this is how he put this clear and present danger test in language which is inimitable. If I may just read it to you. Persecution for the expression of opinions seems to be perfectly logical. If you have no doubt of your premises or your power and want a certain result with all your heart, you naturally express your wishes in law and sweep away all opposition. To allow opposition by speech seems to indicate that you think the speech impotent, as when a man says that he has squared the circle, or that you do not care wholeheartedly for the result, or that you doubt either your power or your premises. But when men have realized that time has upset many fighting faiths, they may come to believe even more than they believe the very foundations of their own conduct, that the ultimate good desired is better reached by free trade in ideas, that the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out. That, at any rate, is the theory of our Constitution. It is an experiment, as all life is an experiment. Every year, if not every day, we have to wager our salvation upon some prophecy based upon imperfect knowledge. While that experiment is part of our system, I think that we should be eternally vigilant against attempts to check the expressions of opinions that we loathe and believe to be fraught with death, unless they so imminently threaten immediate interference with the lawful and pressing purposes of the law that an immediate check is required to save the country. Beautiful words. This takes me to an important judgment of our court, Shreya Singhal, where I happen to be the author, in 2015. And we followed this clear and present danger test as refined later in the later American judgments, now to mean some imminent call to some lawless action. It must be an imminent call, an immediate call. So you exhort somebody to some violence or something of that nature. In Shreya Singhal, what was challenged was on the social media platform, which becomes very important given the media that we have today. So, when you have a social media platform, you had a section 66 capital A of the Information Technology Act, which provided that anything on the internet that was passed by any citizen If that happened to be grossly offensive or annoying, was the language used in the section, then such person could be bunged into jail for up to 3 years. This section came before a bench of which Justice Chalmeshwar and I happened to sit. And in my judgment, I struck down this section on many grounds. We followed the clear and present danger test. We also said that these words are extremely vague and susceptible of misuse. We also said that anything may be grossly offensive to somebody and not to somebody else, may cause annoyance to somebody and not to somebody else. And merely being grossly offensive or annoying doesn't come within the 8 pigeonholes in Article 19(2). But what was said in that case, so far as free speech is concerned, is the distinction between discussion, advocacy, and incitement. Now, we said it is open to anybody to discuss whatever he likes freely, howsoever loathsome it may be to his neighbor. Equally, he may advocate something which is loathsome to his neighbor. But it's only when it comes to actual incitement, where you actually incite a crowd, let's say in an election speech, to do something, that you may curb free speech. And until that stage arises, you may not. The second important thing that we said was the refined doctrine now of the chill factor or the chilling effect on freedom of speech. And we defined that to say that if governmental authorities or let's say a section like 66(a) were to catch hold of people and say you are liable to be sent to jail for let's say up to 3 years because you say something grossly offensive to somebody or you annoy somebody, then the chilling effect it will have on others will be such that unlike in Near versus Minnesota, the few noxious branches will be removed and so will free speech itself. The baby and the bathwater will both be thrown out. Following on the heels of Shreya Singhal was another interesting judgment in 2017 in Justice Kaju's case. Justice Kaju is a retired judge of the Supreme Court. And he called Gandhiji a British agent and Subhash Chandra Bose a Japanese agent. And he is known for his outbursts. And Parliament censured him for this. So he filed an Article 32 petition. Now, 32 petition is a direct petition before the Supreme Court claiming that it is my fundamental right under Article 32 to claim the right to free speech under Article 19(1)(a). The Supreme Court dealt with what he said. Importantly and interestingly said he had every right to say it. But that ultimately there was no cause of action because all that Parliament did was to censure it. It didn't do anything further and therefore threw out the petition. I find that today India is at a crossroads.